And our final speaker on the panel is Gil Holmes, the Dean of the Verne School of Law and my former Dean at the University of Baltimore School of Law, and also a family law teacher and scholar. Gil is going to talk about educating law students to more effectively work in this new environment of need for access for justice and also new dispute resolution options. Thanks, Gil.
Thank you, Jane. Good morning. When Jane asked me to be on this panel and to talk about legal education, I was a little bit lost because legal education has not done a very good job, in my opinion, of training future lawyers to operate in systems other than the traditional litigation-based model. But legal education has a great opportunity now because of a change in the standards by the ABA. The ABA now requires every law student to take a minimum of 6 credits of experiential learning in order to graduate from an ABA-approved law school. And that experiential learning could be handled through a quote-unquote clinic-type setting, but those settings tend to be very expensive. And so law schools are now challenged to figure out less expensive ways to provide their students with experiential learning. And one of the aspects, one of the opportunities now that law schools have is to introduce their students to collaborative practice, to interdisciplinary practice, to practice in ways that are not driven by the traditional litigation model. At the University of Laverne, we've adopted some very radical changes in legal education, but the one I wanted to talk about is our litigation and transactional law track, which is in the 2nd year. These are required courses. I'm going to talk about the transactional law track primarily, which is a coordinated teaching of business associations, sales, and negotiations. Some of you might say, okay, well, what does that have to do with family law? It has everything to do with preparing our students to understand how to work within a collaborative setting. These students work in groups of 4. They prepare a client letter. They decide the entity for their client. We use actors. We use students in the theater department to come in and serve as the clients. And then they draft an agreement, negotiate the agreement, and redraft the agreement in the end. And in that process, students find that the area of law outside of litigation is more, resonates with them more than litigation does. Most people, and I'm sure most of the students in the room, came to law school thinking about litigation because that's all you see. When was the last time you saw a TV show based on will preparation? Exactly. So students now are learning more about other areas than litigation, which then opens them up to thinking about both collaborative negotiations, interdisciplinary ways to practice law, to interact with those who are trying to solve a problem other than filing motions and going to court. And as other law schools adopt these kinds of models, the students become prepared to enter into the profession with a different skill set. I was talking to Melinda earlier about a crazy idea. I'm known for crazy ideas. So one of my crazy ideas is that at Laverne, our process of starting an incubator for graduates who want to go into private practice could sit alongside a program like the one that Melinda described, therefore providing attorneys to work in this collaborative setting. And University of Laverne has a PsyD program, so I would then bring in the students from the PsyD program and start to provide these models for out-of-court, different kinds of dispute resolution that students are trained in, so when they graduate, they're in a position to change how the legal system interacts with families. I also think that family law, and as Jane said, I've been a family law practitioner. I was that for 18 years before I went into legal education. But I think family law can lead the way for total legal reform. I mean, it's not just the area of family law where collaborative practice would benefit clients in general, and I think our society as a whole. But there are other areas of law that would work out, and if we are the ones who really pull this together and make it work, if we can make it work with children, we certainly can make it work with corporations. We certainly could make it work even within the criminal justice system. So as you think about how out-of-court dispute resolution becomes a model, we can think about how we're starting to change the legal system. And law schools, I believe, legal education has a big role in preparing our students to be the leaders to make these changes. Because if we keep producing litigators, we're going to have a system driven by litigators. And even though I was a litigator, I don't think I drive a system very well. I think this way is much more important, much better. And the opportunity for law schools to provide the education, the skills training for our future leaders is very significant, and the opportunity is definitely present. Thank you.